everyone. We are live as far as I can see. Well, we're not live. This is actually being done in post-production. I'm actually doing this live. But anyway, I want to cover um, the back and forth of Judge Darrell and Darrell Brooks. Also, there is a part of the trial where um, Attorney Opper is going to be giving her closing arguments to the jurors, and the way she broke it down. Um, and before, one of the things I noted before they had transitioned into the uh, part of the closing arguments, one of the things that I noticed that Attorney Opera wanted to make sure that before they got started, that Mr. Brooks was able to see in that other courtroom. Because he's going to be ousted and he's going to be in a different courtroom, and they need to make sure that the audio's on, he can see, everything is together. And I said to myself, oh my God, you know what? Sue Opper, is appearing, to make sure that he has all the information he needs over in that other courtroom. But in theory, it's all so that way that we do not miss a beat, that we do not screw up, because we put so much time and effort into this case to convict this man. We cannot afford for him not to hear what's going on in the other courtroom. We cannot afford for him not to see on the monitor. So she is checking with Judge Darrell to make sure before we even go on the record, before we even began with closing arguments, that Mr. Brooks has all of what he needs in that neighboring courtroom. So I thought that was interesting. And it makes sense. Why invest so much time and effort only for that to be screwed because of a mistake that you made or something that you didn't check? Because the last thing they want him to do is to win this thing on appeal, and we cannot afford for that to happen, if that makes any sense. All right, let's go in.
Benefited by conduct. This court, just like it attempted to do with regard to your right to testify and set up reasonable restrictions so as to meet all of the goals that the court needs to meet, will be as follows, and that is, again, sir, you may not bring up matters that are not relevant to the determination of guilt or innocence. That means evidence that was not presented and not received in this courtroom is not relevant to your closing arguments. It's not, the arguments must be based on the law, not as you interpret the law, but as the law is. You must base your closing arguments on the facts that have been established during this case, meaning the evidence, the testimony. As I indicated earlier, the purpose of a closing argument is to summarize the facts, marshal arguments, and focus the issues for the jury. It is fair that you comment on evidence, including arguing evidence to the conclusion or inference. It is your ability or your opportunity to convince the jury that you are not guilty of these offenses. You may not convey any idea that you have undisclosed information. Neither party may vouch for a witness or otherwise express personal belief or opinion.
Let me say this. She is reading this as she should. That is her job, to go over case law. And so anything that she does during the trial, and has to be according to the case law that she's citing. But my issue is here, Darrell Brooks is not going to abide by any of that. And of course she's doing her job by going over it, but this is not going to move the needle in terms of him conforming to this. That's not his plan. He knows he's going down. Darrell is fully aware of that. He knows he's going down. He's not going to conform to the rules of the court proceedings. It's just not going to happen. And so then he goes back to debate her on this, and now we're in a tangent. We're away from the substance, And this is one of the things that I argued in terms of how I would have dealt with maybe in a case like this, or even a case like this, if I had a defiant defendant that was giving me all this ruckus, all these issues incessantly like this. Number one, I would not go down a tangent with him because, number one, I'm not his attorney relative to explaining law to him. All right? I'm not, whatever you don't understand, I don't have nothing to do with it. I'm just a referee in this. I am the umpire in this. I'm calling the shots as I see it. All right? And so every time Darrell would go down a tangent, it was wasting time and it was preventing her relative to getting to the next phase of the tribunal. I would not have entertained it if it hadn't been me. I'm just saying that. And so, again, she's reading this, but it's not going to get him to conform to that because there's going to be a debate that's coming up. Let's go.
Regarding truth or falsity of any testimony or evidence, it would be improper to ask a jury to draw inferences that the parties know are not true. And your comments on evidence is limited to evidence in the case. You may not comment on facts outside the record or peculiarly within your own knowledge. And that is just some of the guidelines for determining the proprietary of arguments that I am guided by from my judicial bench book and all of the cases that are referenced therein. So you are put on notice, sir, that even without an objection, this court may, in an effort to preserve the dignity, the decorum, and to keep the issues properly before the jury, may advise you during your closing argument to move on. If you do not honor the court's rulings, then you will run the risk of forfeiting your right to be present and potentially forfeiting your right to further present your closing argument. With that, I am bringing this jury.
Now watch this. With that, now notice she's trying to move forward now. She's already laid the foundation in light of what she expects. All right, when he goes before the jurors in terms of a closing. Okay, she's now trying to move to the next phase. Now, this is not to his satisfaction. So now there's a debate. Here we go.
Out to complete the instructions that I need to complete to add to the credibility instruction, the paragraph on implicit bias, and to let them know the full instructions that they receive will have it, to read 160 closing arguments of the parties, and then to have the state go first as they bear the burden of proof.
Now, Your Honor, I'll just let you make your record. I didn't overtalk you. I didn't interrupt you.
Here we go.
Is that fair to say?
It don't matter. See, that's what I'm talking about. Here we go with another debate. She's trying to move forward, and he's coming in with this crap.
I'll let you make the record.
You ain't let her make shit.
With all due respect, when will I be able to make the record? As I've tried to do numerous times by saying I wanted to present an offer of proof for my appeal. That's the chance for me to be able to make the record.
I'm denying your request to make an offer of proof regarding your appeal. I'm not allowed to make the record at all, Your Honor? Sir.
I'm not allowed to make the record at all? As I just let you did, because some of the issues has been...
You have told me what you want to do. I've told you can't. I've addressed the request.
Some of the issues have been me over talking you and interrupting you. I did not do that.
It doesn't matter. She made a ruling. Now let's move on. What are you debating her for?
Even though everything that you said, you have not proven for the record, and it's unlawful law. You haven't shown one time that is lawful for you to do what you've been doing.
Mr.
As far
Brooks,
as your rulings.
Once again, I'm not going to
up.
debate with you the prior rulings of this court. There's absolutely no need at this point for you to make
Honor,
an offer of proof regarding my prior rulings or decisions that you disagree with.
Your Honor,
you will have an opportunity, if convicted, to raise every issue you want on appeal.
I'm going to inform the jury of the truth, their duties, and their rights.
Now, all right, so no. Before I get upset, because y'all know I get heated, I get boiled, especially when this man is talking, because he says the most dumbest things to the likes of which no one has ever heard. But listen, why would he? What gives him the right to even believe that he has the authority to tell the jury of their rights when they were giving all of that, when they were given all of that information, watch this, from a judge that gave them jury instructions, so they are aware of their rights? What gives you the right? You are not the judge. So by definition of that, you don't have the inherent right to inform them of their rights when they were given their rights, you fool.
As I have the right to do under the First Amendment and under the Sixth Amendment. You can't just disregard the United States Constitution.
You can't disregard her as a judge and think you have the inherent right to tell them when they were already given their right by her. You're disregarding her authority. Come on, man.
You can't do that.
Yes, she can.
Again, any law repugnant of the United States Constitution is null and void.
Anybody that was repugnant is what you did. Your act. What you did at that parade was absolutely repugnant. Hey, watch this, y'all. And this is what I'm talking about. He's trying to put her oath of office, or it's got to be relevant of her oath of office. Her oath of office is not on trial. Why is he diverting from what he did that was repugnant and try to make this about her oath of office and which she doesn't have the inherent right to do, although she is a judge? But then he wants to talk about her disregarding his rights. What do you think he's doing?
There's no state law that you can cite. There's no federal law that you can cite that overrides the United States Constitution.
And there's no authority that you have to say that.
Mr.
You know
Brooks, I
this.
direct your attention to State versus Anthony. Although that case dealt with the right to testify.
Okay, so
its
we're not
reasoning
talking about the
is
right to
equally
testify.
applicable.
We're talking about the closing arguments, correct?
See, this is what I'm talking about. Judge Darrell don't even need to be going into the case law right now. Leave that alone. He's not trying to conform to that. I don't care what case law she says or cites. It's not going to matter in terms of him conforming to that. So that's irrelevant to even go into. He's trying to make this a debate. He's clearly leaving the substance and going into a whole different, really, abyss, because that's where he's going to end up, right? The abyss of hell. The abyss of hell. And so he's trying to keep maneuvering, and she's falling for it. No, we need to bring these jurors in here. We ain't got time for this fool. Either do it or oust the fool. Or oust. Get him out of here.
We're not talking about testifying, which you
Mr.
already
Brooks,
made.
Mr. T used to say years ago, I pity the fool. Get this fool out of here.
I'm going to delay
You
any
already
further
made a ruling
closing
on,
arguments
but
of
Your
the
Honor,
parties.
with all due
I will
respect,
address your further request.
with all due
once the
respect,
state-
you already made a ruling about
Judge, just get him out. He's trying to make this a debate. He ain't listening to you, the case law. Come on. Just leave that alone. Just get him out. Come on.
testifying. Did you or did you not?
Get him out.
Mr. Brooks.
So we're talking about closing arguments that I said it's my right to be able to inform the jury of the truth.
It is not his rights. He's not the judge to give them case law, or not case law, but he's not the judge to give them jury instructions. They were already given those. What are you talking about? So this is clearly, he's trying to stop.
Their duties and their rights.
That's wrong.
That is my constitutional right.
Mr.
That's a
Brooks,
lie.
we
You
are
can't
at the stage
tell
of
me
the
I can't-
proceedings where it is the state's burden of proof where they get to make their closing argument.
We're talking
first.
about me though.
Judge Darrell, why are you even entertaining it? Why are you don't even have to, you're not his attorney. He's not going to listen to that. He's going every time Judge Darrell says something, he's gonna try to find something and try to argue with that. And she says something else, he's gonna find something else. And all that's doing is throttling, all that's doing is slowing everything down and making this about him, them against him. That's all this is about. I would not have entertained it. I'm sorry. He would have been out of my courtroom by now. He would have been out. So what? Go to appeal. I'll tell them that I did it. Yeah, I did it.
Understand that, sir, but
I'm gonna
Because it warranted it. That's why I did it.
inform them of the
conduct
truth.
right now is delaying
I'm not intended
the court's
to delay
intention
anything.
of
Exactly.
I
moving
let
forward
you,
with the
Your Honor.
closing argument.
I
Get
just
him
sat
out
there and
now.
let you make the record. I didn't overtalk you or
Shut your
interrupt
mouth.
you. I let you say what you wanted to
Get
say.
it? No, you ain't let her say shit. Get the fuck out the damn courtroom now.
I let you make the record.
No, you didn't.
I didn't interrupt.
I can't take
All
him out.
right,
Get him
under
out.
the first-
Get him out. Get him out. Get
Be
him out.
held in contempt.
Let's go. Let's go.
Even
Advising
mute
you
me.
No, get him out. Get him out.
You're using the mute button.
rules of decorum and courtesy. He has repeatedly talked over me. He's
Yeah,
repeatedly
get
interrupted.
him
Even though
out
I've made
now.
rulings, he's not respectful of the fact that I made a ruling, even though he disagrees with it.
How can you
I
make
attempted
it?
to bring the jury out.
How can she make a ruling? Because she's the judge. She's a judge. What kind of dumb question is that?
How can you
And
utilize
Shut
the
up.
mute
he
button?
continued to talk.
That's
So, Mr. Brooks, you
Your
have
Honor.
forfeited.
How can she utilize the mute button? Are you asking Bubba how come he's utilizing what's between his legs? Woo, let me get out of here. I'm sorry. Bubba utilizing something in between them buns. So what you telling him? How can you utilize? Get out the courtroom.
Your right to
Is
be
that-
present for
Get
the
him out.
state's
is that
closing
not?
Shut
argument.
up.
Your Honor,
You will
can
be
you answer
taken
this
to
question?
the
No, we
courtroom
don't have
next
to-
As a
door, and I
public
will
servant-
invite you back
Shut
over
up.
when it's time for your
You can't
closing
invite
argument.
me back over. I can
Shut
reclaim
up.
my right. So how can you
Get
invite
out.
me
All
to
right,
do
the
anything?
courtroom
Get
is
out.
to be cleared so that Mr. Brooks can be removed
Get
to the
out, you
next courtroom,
dirty-
and I'll make appropriate
dirty
findings
piece of
findings
crap.
when he's in the other
Yeah,
courtroom.
Get out
I
of
will
the
do
and
so
you'll mute me, which you
without,
can't lawfully do.
Get out of the
interruption.
courtroom.
You can't lawfully mute
Yes, she
me.
can. She moving you now.
So now you're
She moving you now.
trampling over my first
Shut your mouth. I'm sorry, y'all. This fool just got my blood boiling. Woo. Baby, yeah. See, this is why, when I first was making Darrell Brooks videos, I would do it every day. But now he got me so mad, man. I be doing it once every 6 months so I can keep my cool for because I be pissed. I mean, I really be pissed off. Like I am now. But there were so many factors that played into this case that made me like extremely upset, man. How he would laugh and make gestures and stuff in front of the witnesses. And they were the ones that lost their loved ones. And he's making this whole thing a caricature. Because Brooks is a character. And that character got put away for the rest of his life. Why? Because he chose to play a game of Russian roulette with the law. That's a game you don't want to play, my friend. That's a game you don't want to play. I learned from an attorney a long time ago. If the appeal is better than what it looks like or the potentiality of what it's going to look like on trial, you better take that appeal. You better take the appeal. And what I mean by appeal means take the plea agreement. If the plea agreement looks a lot better than what's potentially going to look like in trial, because the problem with trial is this. The problem with trial is a level of uncertainty because you don't know what's going to play out in that trial. And so if there's a plea agreement that looks a whole lot better than that, you might want to jump on that plea. Now, Darrell Brooks didn't have any solace either way. Because even if he would have got a plea agreement, he was still going to jail for the rest of his life. I mean, come on. Given all the times that he's committed crimes over the years, and he continued to do those crimes all because of his indigence, And the reason why I say his indigence is because, he didn't have the money to get out of jail if the bail would have been heightened to $5 million like it was in this case. That's why he stayed in jail for a whole entire year. He couldn't get out. Why? Because of his indigence. But what I'm saying is, if his indigence was an issue, then they should have had that bail there from the door. Maybe all these people at the Waukesha parade wouldn't be killed. Where will they? Will they be killed? I don't think so. And so I know somebody was telling me that Waukesha, Wisconsin is a Democratic state. But at some time, listen, I don't care whether it's Democratic or Republican. At some point, common sense has to kick in. I don't care whether you Democrat or Republican. At least have common sense. And common sense says that this man should have never been allowed on bail. I don't care if it was a Democratic state. Come on. So what are you saying? The Democrats don't use common sense? Well, apparently not. But what I don't understand, why did it take an incessant? I mean, he did these crimes incessantly, back to back. Why did it take to this crescendo or this climax to now warrant, okay, we got to raise that bail, man. We got to get it up to $5 million. Because if he's indigent, then there's no way he could ever come out. Now that's using common sense. But I just wonder why common sense wasn't used initially. All right, now the next phase of this trial, we're going to go into the closing arguments, and we were already looking at Mr. Brooks telling Judge Darrell, telling her, although she's the judge, but he's going into business for himself, telling her what he's going to do, talking about the jury's rights and what they have when they have already been informed of their rights. So anything that he's telling them in terms of him telling them about her oath of office, that's irrelevant because her oath of office is not on trial. Him telling them that he was shocked or had the shock device on, that's irrelevant. Why? Because his custodial status was not on trial. What was on trial is the atrocity that this man committed at the Waukesha parade. That's what's on trial. That's what's relevant. And one of the things I like that Sue Opper said, we're back on the road. Let me just say this before we get right back on the record. One of the things I like about Sue Opper was that she made sure how she laid this out to the jurors. She said, please obey Judge Darrell. Please just make your comments relative to what he did at the Waukesha parade. Not anything he did before. And we're glad he ain't going to do nothing after because he going down. But my point was she laid it out to the juror. Please just deliberate on the facts of what he did. All right. So that's basically cutting off the likelihood of him talking about or wanting sympathy for him, because that's not what this is about. They are not to rule on sympathy. And like I said, they were already given jury instructions. They were given that information. But this is just a testament of Sue Opper letting them know. Just deliberate on the facts as they should. All right, let's jump back in here as we're waiting Judge. So as you can see, he's already been ousted from the courtroom. He is in the neighboring and or adjacent courtroom. And Sue Opper is going to ensure by asking the judge if, in fact, that he can hear and has the necessary equipment as it relates to what's going to be ensuing in the main courtroom. Darrell is gesturing right now. What is he doing? We're not officially back on the record, but we can see this fool in question. Not only is he the fool in question, but there's a vehicle in question that he didn't want the jury to see, called the jury view. And I don't know why he didn't want the jury to see that, because that is definitely relevant. Y'all remember he said, I don't see the relevancy of a jury view. That is definitely relevant because that is the vehicle in question, just like we're looking at this fool in question. It looks like he's arguing. He doesn't look like a happy camper over there. I would assume. He looks rather pissed off, as he should, given that he didn't care. He was absolutely indifferent relative to his actions on that infamous day. He was insouciant, meaning that he didn't care, he didn't give a rat's behind. And it was viewable, as seen. It was conspicuous during the victim impact statements because he did gesturing that was inappropriate. So he's looking at the screen, so we can see this fool, and this is the 17th day of the tribunal. Can you imagine? I said this earlier in one of the other videos that I did with Darrell Brooks. Can you imagine what they had to go through in real time? See, we saw this online and we seen it, but can you imagine they were actually in the courtroom. They dealt with this in real time. And one of the things that Sue Opper was asked, even post conviction, once they got their conviction and he was led away. I like that word, led. He was led away by authorities. And by the way, did you see the size of those sergeants? Oh my God, he looked like a little puny little thing. Did you see the sheer size of those sergeants in that room? And it's crazy. He had the biggest mouth in the room. And if those sergeants wanted to, they could have ate him up, destroyed him. But anyway, post the conviction, post all of that, Sue Opper was asked in a press conference, what was it like going up against Darrell Brooks? Did that change your strategy? What was your focus? How did you maintain holding your peace in that, not going off, or, and obviously, as we can see, there were some people that were in the audience of this trial that he couldn't contain himself. He said, "Go to hell." He said, "Burn in hell, you piece of shit." Y'all remember he said that? Y'all remember he said that? But I believe that he said that out of joy because he knew.
So I need it quiet in the courtroom, please.
Because he knew.
We are back on the record. Appearances are as they were before, except that Mr. Brooks has been removed to the other courtroom. The court did that because we came out on the record at 2 o'clock following the lunch break. Mr. Brooks was brought to the main courtroom, and during that almost 35 minutes or so, he was insistent on raising a variety of legal issues with which this court has either previously addressed or which are meritless and do not warrant any further response. He is insistent on making a record and an offer of proof. This would not be the appropriate procedural mechanism, meaning an offer of proof at this time. We are not in the midst of a trial where the court's made an evidentiary ruling that would require the preservation of the record by making an offer of proof. This court has been attempting, frankly, all day to get through the reading of jury instructions, to get to the point where the parties make their closing arguments, and ultimately to put this case in the jury's hands. It has been challenging. It has been met by resistance from Mr. Brooks. I would once again describe it as being stubbornly defiant, although at times he may wait for me to make my ruling. He continues to not respect the fact that a ruling has been made, and he wants to argue and re-argue and re-argue points that this court has already gone over. And in an effort to simply put him on notice regarding his behavior, given the history of this case, the court was attempting to set some parameters regarding closing arguments so that they are focused, so that they are proper, and that they follow the law. That was met with a considerable amount of resistance and repeated statements by Mr. Brooks that he has First Amendment rights, Sixth Amendment rights, 14th Amendment rights. He has all of those rights. That is not in dispute. But those rights do not come in a vacuum when we are in a court proceeding, in a trial such as this. The rules of evidence, the rules of procedure, the rules of courtesy and decorum all apply. And this case has demonstrated that a stubbornly defiant defendant can forfeit even important constitutional rights by conduct. That includes the right to be present. It included the right to present further witnesses and testimony, and it included the right of the defendant to testify on his own behalf. I hope that I do not have to go through a decision that forfeits his right, or that makes a finding that he's forfeited his right to make a closing argument. I will certainly wait and see how that goes. I would note he was very respectful when he did his opening statement. It was clear. He made a variety of points. He did so in a way that I would say was very conscientious of people's time. It was cogent. It was concise. It was probably about 35 minutes. I may be off a little bit, but that's what my memory is. It wasn't overly lengthy. I would hope that he follows some of those same things here when he does his closing argument. But he has been removed from this courtroom because of his stubborn defiance and disrespect of this court, of courtesy and decorum. And what I truly believe is an effort on his part to continue to delay and lengthen these proceedings. I've said it before, I'll state it again. It is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. And trial courts and trial judges that are confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. They noted 3 constitutionally permissible ways to handle such a stubbornly defiant defendant. But they also indicated that no one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. I've noted this before. This is a case from 1970. The technology that we now have in this brand new courtroom was not available then. I have the ability to have Mr. Brooks appear from the other courtroom by way of audio and visual means. We can see him, he can see us. I've confirmed prior to calling the case that the audio was working, that the video is working. The one camera, there's 4 cameras in my courtroom, there's 4 cameras in his courtroom. However, it is set to 1 camera since he's the only individual there, other than the bailiffs, but I'm talking about as a party to the litigation. So the courtroom, the cameras in my courtroom include one that would normally be on the witness stand that has been zoomed out so as to capture the large majority of the jury box. I even adjusted the camera that's on the state's table so that the exhibit that's currently up to my left, her right, Attorney Opper, is viewable.
And I like how she's getting this, and we're going to fast forward to when Sue Opper is ready to give her closing. But I like that she's getting all of this precisely on the record, so that way they can understand why. So that way there's no... Look, Judge Darrell cannot afford for Mr. Brooks to go free. No different than the state can't afford to allow him to go free off of a technicality, off of something that they may have missed. And this is why it's necessary to document everything, all right, so that everything is up, it's in the open. The Court of Appeals knows everything. This is that she's making sure that there's no Brady violation. You guys are being informed of exactly what's happening, why this is happening, why I think this is happening. As she said, she believes that he's doing this squarely for the purpose of trying to stop these proceedings. He's trying to extend this when she's trying to move forward. And I like that. She can't afford for him to win. The state can't do it either. And so all of this is necessary. Now, let's go to the other part. I want to fast forward here once we get to the closing. The closing. All right. Here we go. I think this is it. Here we go.
Similarly to what we see, so the monitors will display the camera that Mr. Brooks is appearing, that is on Mr. Brooks on the left-hand side of the TV, and then the 4 cameras for this courtroom are on the right-hand side, but it's probably maybe a quarter to a third of the screen, and then the remainder of the screen.
Wow, you notice she's getting detail. I don't know how much more detail you can get. She is making sure that there's no likelihood of an appeal. I know that's right.
Is the PowerPoint. The monitors in the courtroom that Mr. Brooks is in are no different than what they are here. Wow. He would have one at the table, but there would also be the very, very large TV monitor above the clerk over there. Well, it's smaller, and then the very large one over the witness stand. So it would be very similar to what is here if he were present in this courtroom. And again, I know that the diagram, it's probably not the most easily seen from a camera, but it's really no different than what I'm looking at the moment. So I appreciate you asking that I make a record of that.
You notice? Watch this. Do you notice she said, I appreciate you asking me to make a record of that? That's why I said the state can't afford for him to win on technicality. They suggested that she get all of that in detail. So that way, because it's so much that they invested in. All that evidence, all that time and effort and money, the state, come on, man. They were not trying to miss anything, as well as they shouldn't. Come on here.
I would further make a record that there are headphones on the table where Mr. Brooks is currently standing. He has not put them on, but they are available should he want them. All right, then are you turning off the PowerPoint? Let us know when you need that function, and then Madam Clerk will be able to make that.
See, they confirming everything. Let me know. We got to make sure that he can see, he can visualize what's going on, because you ain't going on the pill. Talking about I didn't see nothing. I know that's right.
Viewable in both courtrooms.
Very good, thank you.
All right, with that, the jury is to be brought out.
Here we go. Here we go, ladies and gentlemen. It's going to get fire. 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 And the only reason why I say there's going to be fire is because the way Opper laid it out to this jury, oh my God. I mean, it was almost like you were there, like eyewitnessing it, the way they described it. And then there was one point of this where it almost felt, it was like a silence had went over when they were actually viewing, looking at the footage of Brooks driving through that parade, which we were not permitted to see. And by the way, I would never want to see that. That is horrific in and of itself. But you can tell the emotions even in...
All rise for the jury, please.
You can tell the emotions when they went into a mode of silence. There was a silence that went over this courtroom. It actually felt like a funeral. It felt like you were at a funeral. And when it was all over, Judge Darrell needed to take a very significant 10-minute or 15-minute break because of the emotions that had flown so high in this case. As we can say, Mr. Brooks, he is in the other courtroom. He's been thrown out. This is not a good look for him because the jury is coming in and they're going to see him in that neighboring courtroom. So they know that something is obviously wrong. They know that he...
Thank you, everyone. Please be seated.
They know that he did something as to why he's there. And guess what? Judge Darrell is going to make a record of that. Let's go.
Ladies and gentlemen of the jury, when I read the jury instruction to you previously regarding credibility, I had a prior version of the jury instruction. Now, what I read to you in the very beginning, or at the very beginning of this case, was the most recent. I am going to read a short paragraph, but also tell you that in the packet that will be sent with the jurors to the jury deliberation room, it will have the complete instruction. And it's
Let me say this. I think the reason why, if you notice, she already said that she had read them, but she wanted to read again. I think the reason why that she is agreeing to read this again to them, because Darrell Brooks already said what he was going to say on his closing, which was what? Reminding them of their rights. So Judge Darrell is already getting this out the way with them, reminding them, now wait a minute, you are already giving your jury instructions, so let me go over it back with you, so that way you know what you're supposed to do, not what Darrell Brooks is telling you to do, if that makes any sense. Let's go.
instruction number 300, excuse me. And this is what I want you to know about credibility. In your determination of credibility, you must avoid any and all bias based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic.
Now, and you notice that and Darrell hears that because he can hear what's going on in the other courtroom. So Darrell knows why she said that. Because he said what he was going to remind the jurors of them, and she is basically refuting that. He is not the judge. He does not have the official capacity to tell them their rights in terms of the jury instruction. Not at all. Not even. So I like what she's doing here.
Consider carefully the closing arguments of the parties, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given you by the court. With that, I will ask Attorney Opper to start with her closing argument. Go ahead.
Thank you. And Madam Clerk, if you would please turn on the PowerPoint. Yes.
You notice she said, please turn on the PowerPoint so that way Mr. Brooks can see that. They are carefully going through this. Oh my God. They are making sure that there's no room to breathe when it comes to his appeal. I know that's right. It's really sad how she lays this out.
Hold on one second. Mr. Brooks, do you have an objection?
I thought I was supposed to be unmuted.
You are now. All right. Attorney Opper, you may start.
Thank you, Judge. Good afternoon, everybody. It's kind of nice to stand here in the middle of the courtroom. You know, all week or the last 3 weeks, they shoved me at the end of the table because I'm the lefty in the group. It's nice to be able to look at you all and say thank you. Truly thank you. Each and every one of you. I want to express our sincere gratitude from the prosecution team, myself, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Woodshow. There's no one in this courtroom that does not realize the sacrifice that you've made serving your community in this very important task. You've put your lives on hold. I don't even want to hear from your bosses. Thank you. You've watched these proceedings and you've noticed as we sit at our prosecution table, we don't have a client at our table. But rest assured, we do represent someone. We represent the people of the state of Wisconsin. It's an entity. I can't bring it to the courtroom. People enact laws. People want to feel safe. People have representatives in Madison or Washington, D.C. that set standards, rules that we all are expected to live by. And when those rules are violated, prosecutors step in and enforce the law. Darrell Brooks does not represent anybody. He does not have a client. Darrell Brooks is the client.
She's exposed.
Darrell Brooks is the defendant.
Yeah, but who didn't know that though? I mean, I'm pretty sure the jurors knew that. He knew that. Everybody knew that. She is exposing this fool for what he is, and apparently for who he's not, because he certainly ain't no damn attorney. Come on.
The state of Wisconsin is the plaintiff. It's really that simple. And it's consistent. Any other criminal case you've ever heard about at any other time in any other jurisdiction, it runs the same, no matter what state or federal. I'm going to ask you for your guilty vote at the end of my comments. It's up to you. I can't tell you to do anything, except I'm going to say one thing to you that I wholeheartedly ask you to obey.
Attorney Opper, I'm sorry for the interruption. Your objection, sir?
Mischaracterization of who I am and the way it was said. I feel like it was talking down.
I think it's true.
All right, your objection's noted. It's overruled. The statement can.
I think it's true that it's true. Everything she said is true. So how is that a mischaracterization? Not at all. Not in the very least. I think that she said everything, and he doesn't have the right to really object that anyway. Given that it was true, and given that this is closing.
Continue.
You must not consider anything about Darrell Brooks other than his conduct in downtown Waukesha on the evening of November 21, 2021.
Exactly. Now you notice he just hold up an objection. The reason why he did that is because he wants to have them roll on sympathy. She's trying to bring it back to the substance. No, the substance is what you did at the parade. Not about, your daughter, because y'all remember when he got up there, started talking about his daughter and his family, and completely disregards the families of those victims who he victimized, who he made their lives a living hell because they don't have access to their loved ones anymore. But he wants to make this about him. So this is why he's holding up that objection sign, because she is squarely letting them know, please obey Judge Darrell. Please make your conversations elaborate the facts of what he did at that parade. Exactly. Let's bring it back to the substance. I love Attorney Opper, how she's reminding them. And it's all true. It's all true. Because what he did is on trial. Not anything else. What he did, his conduct and or his misconduct, is on trial here. Not the judge's oath. I can keep on going, but let's go.
Nothing he's done before that. Nothing he's done since that.
Exactly.
When you go back to that deliberation room, please obey Judge Darrell.
Yes.
Confine your comments to his conduct on November 21 of 21.
Now, why is she pleading, saying, please obey Judge Darrell? Because she inherently knows that they can go in there and swing this in his favor. They can, if they really wanted to. You think that was that's what happened in the O.J. Simpson trial? Everybody know he was guilty. But because of the time in which that occurred and the society at that time, there was sympathy that sympathy, and they went above and beyond and turned the whole verdict around. So this is what this is why the jury is informed not to deliberate relative to any type of conflict of interest, whether it be race, whether it be gender, whether it be any of that, because that has nothing to do with the facts that are presented in this case, which would warrant the jury to deliberate as such. Come on.
Is he guilty of the 76 counts that he's been charged with?
That's the point.
That and solely that should be your topic of discussion. So, what are the charges against Darrell Brooks? Thank you for your patience in listening to the jury instructions. They must be read. for each and every count. But sadly, they can be summarized very quickly like this as far as the actual counts.
Wow.
Counts 1 through 6 are first-degree intentional homicide while armed with a dangerous weapon. Counts 7 through 67, first-degree recklessly endangering safety while armed with a dangerous weapon. Counts 68 through 74, hit and run causing death. Counts 75 and 76, bail jumping, and count 77, battery.
Whoa, whoa, whoa.
Mr. Brooks, what is your objection?
I have 76 charges, not 77.
Now, let me ask you a question. Even though he's right, but how's that helping him? Because he's talking about the bail jumping. That's not, even if he was right about that, that still ain't helping you. You're exposing yourself because you wasn't supposed to to bail jump from the get-go. Mr. Brooks committed these crimes because of the bail jumping. He did that out on bail. So that's even worse. So even if they don't convict him on what he did, they got to do it on the bail jumping. He guilty of that alone. Come on. That ain't helping you. So what's your right?
It's a mischaracterization of the charges.
That is correct. It is sustained. It should be count 68
But
through
it's not helping
73, I
them, though.
believe, and then 74 through 75, and then 76.
Thank you, Your Honor.
If I was him, I wouldn't have said anything because it wasn't going to help you either way. Like, shut the fuck up. Look at that little grin on Judge Darrell because she know this dude is dumb as fuck.
I do apologize for my math skills. 68 through 73, 74 and 75 are bail jumping, and 76 is battery. I apologize for that misstatement. We're going to talk about counts 1 through 67 in detail.
Wow.
Counts 68 through 73, hit and run causing death, in my opinion, are easily summarized as this. He never stopped. Never.
Kept on going.
Bail jumping, he was out on bail for 2 files in Milwaukee County, facing felony charges there. He was ordered to not commit any further crimes. If you believe he was involved in any of the conduct charging counts 1 through 67, you should find him guilty of bail jumping. Battery, that relates to the split lip and black eye suffered by Erica
Patterson.
We told the story kind of backwards. We started with the battery for background.
Well, you know, that's how they started in the interrogation room. They started with the battery, the whole issue between him and Erica. You know, and Darrell tried to accuse them of withholding, watch this, Brady, withholding information of what he alleged of them of knowing, but in theory they didn't know because they didn't get everything, all the facts all at one time. It was developing. And so how she's stating that they told the story backwards, but they started with the battery, that's exactly how it happened in that interrogation room. Just a note, fun fact.
First-degree intentional homicide. You've seen this in our opening statement. You've heard it from Judge Darrell. Did Darrell Brooks cause the death of the victim, a victim? Did he act with intent to kill, meaning either the mental purpose to take the life of another or was aware that his conduct was practically certain to cause the death of another human being?
By the way, if I can just say something here, and this is something that I didn't realize that Attorney Opper had brought out relative to the conversation involving Brooks and the officer when he was upon his capture. Brooks had told them that he knew, watch this, keyword, watch this, that he knew that there was something going on at the parade. Well, Attorney Opper, as you will see, will bring out the fact that it had to be by intent because Darrell Brooks told one of the officers that he knew something was going down at the parade. So if he knew something was going down there, then why would you drive through the parade and kill those people? If you knew. So it had to be by intent. And I didn't catch that. Because you know what? There's so many different variations. You have people that comment on this trial. You have people that's giving their viewpoints, their analysis of how they see it. And all this time that I've reviewed this case, and by the way, I've been talking about it over a year. But as I've been asserting and as I've been viewing this case, this was the first time that I actually took into account relative to Sue Opper saying that Darrell Brooks had informed the police. This is upon his capture. When he was captured by Rebecca Carpenter, he said that he knew something was going down at the parade. So that proves intent, because if you know something's going down there, I don't think you would be behind the wheel and driving through that parade, watch this, with the intent to kill if it wasn't by intent. If that makes any sense. Come on.
Count 1, Ginny Sorensen. Count 2, Lee Owen.
Wow.
Count 3, Tamara Durand.
Oh, I got.
Count 4, Jane Kulik.
These are the victims
Count
that died.
5, Bill Hospital. Count 6, Jackson Sparks.
Wow.
Those are the individuals
That
who
died.
lost their lives because of the conduct of Darrell Brooks.
And misconduct.
From there we go to reckless endangering safety. What is that? In this case, it means that through his reckless driving, he endangered the safety of other people. And he did so demonstrating utter disregard for human life.
Yep.
Now, behind me is State's Exhibit 15. It's also on the PowerPoint. If you choose, you may have this chart with you in the deliberation room to help you walk through each of these counts if you find it helpful. It's up to you. If you don't want it, you don't have to have it. But it will be available for you if you ask for it. And it'll take you, as we did in our presentation of the case, right down Main Street and address all the counts that were involved, all the counts that were charged. To prove reckless endangering safety, and I'm just going to go back one slide, nowhere do you see there that we have to prove any degree of injury to anyone.
They don't.
Never once did Judge Darrell instruct you that somebody has to be physically injured. Now, Detective Casey told you that was the standard we used in deciding of all these hundreds of thousands of people who is included in these charges. And a decision was made by the prosecution team to include people who were physically injured to be efficient in our prosecution. And so everybody up and down the street, I would argue, had their safety endangered that day. I didn't charge 5,000 counts. We selected 61 counts of people that we can identify by name in Exhibit 15 that were injured by the conduct of Mr. Brooks. Those are the people in green. People in red are the fatalities. And we presented this case to you in much the same fashion that is presented here on Exhibit 15 as to how the injuries occurred going down that street. So we are absolutely held to our burden of proof and the elements for each offense that Judge Darrell instructed you on, but we are not required to prove any injury to anybody. The question is, was their safety endangered by his reckless conduct, his reckless driving? Now, some of the groups, it's pretty easy. They walked in a formation, and you can get a photograph or a diagram, and you can kind of see pretty easily who was located where, right? And you can think back to the videos that you've seen for each of these groups and remember, and you'll see them again, the path of the vehicle as it went through each of these groups. This is South Band, of course. All of these names that are being displayed on the PowerPoint Exhibit 21 are on Exhibit 15 in green for Waukesha South Band. Pretty much the whole left half of the formation was endangered by the safety of Darrell Brooks driving up the side of that band. The extreme dance team, it's a little difficult to read, but again, this chart was marked as an exhibit. It's exhibit number 33. If you want it, you can have it in the jury room. The names on this chart will match the names for the extreme dance team on State's Exhibit 15. All of the girls that were struck and injured as they marched with the extreme dance team, plus some people on the back that were handing out candy or serving in support roles as the unit made its way down the street. The dancing grannies. State's Exhibit 54. The formation that they marched in, who was located where, and your recollection of how that SUV zigzagged through that group. And you can just see the names and match it up to who was injured and killed versus who wasn't. Now, one of the big things in this case has always been, why did this happen? What was he thinking? Why did he do this? Again, those are things I don't necessarily have to prove to you. His intent, I do have to prove, and I submit without any doubt there's overwhelming evidence that this was an intentional act by Darrell Brooks and an act of utter disregard for human life. I say that for these reasons, folks. Number one, first and foremost, just stop driving. That's it. It's really that simple. Not one person had to be hurt that day if he would have just stopped driving.
Excuse me, Attorney Opper, your objection, sir?
You specifically, I'm sorry, can I be heard?
Your objection, sir?
I didn't know if I was on mute or not.
You're not?
You specifically said in your jury instructions that intent cannot be, you can't look into someone's mind, I think is what it says.
Hold on. Okay. All right. I thought I was talking, but I had the microphone on mute. Wow, look, that's a lot of overlap given that Judge Darrell has the mute button and she can control this fool. But anyway, do you notice he said that he interjected to let Judge Darrell know that she specifically said, watch this, in her jury instructions. Notice he said that. But then he wants to make an infraction of those jury instructions by informing the jurors of their rights when they were already given jury instructions. So what is he talking about? What is the purpose of his objection? Why is he objecting to try to say what she has said during the phase of the jury instructions? What she said in that. And then he completely disregards that. Watch this. To try to help him when he goes to those jurors to try to tell them of their rights. That is an infraction. That is a clear infraction.
Find intent. So how could that be characterized as someone knowing for sure intent or not knowing for sure intent?
You're making an argument. You'll have an opportunity to do that later. Your objection's noted. It's overruled. The state may continue.
Thank you. Now shut up.
I apologize.
We showed you at the very...
But hold up, y'all. That didn't make sense. He's trying to come into defense by stating that what she had already told them on the jury instructions. That that attorney Opper can't talk about what's on a person's mind to constitute a warrant, a something that's of intent. But now he makes a complete 180 when it comes to him wanting to tell the jury of their rights to nullify. That doesn't make sense, man. That is crazy.
Very beginning, remember our first witness was Sergeant Warner, the man who was the incident commander for the parade. We put up another map. I think it states Exhibit 1. You can have that if you want it. Shows all the positions of all the police officers and the reserve officers, the barricades, the squad cars.
Wow.
How do I know it was intentional?
Obviously.
Because even Darrell Brooks told Detective Carpenter, I could tell something was going on downtown.
All right, let me say this. I did make a mistake when I said that, because, see, I get Carpenter mixed up. I know Rebecca Carpenter was the woman that had captured him initially, and it was Detective Carpenter that did the interrogation. So he, in fact, told Carpenter that he can tell that something was going on at the parade, as opposed to what I had said, that he had told Rebecca Carpenter what was going down at that parade. So now that we have that clarified, but this was the point that I was trying to make earlier that I didn't see when she clearly said, and it makes a whole lot of sense because it goes to intent, the questioning of intent, which means it should not even come into question whether it was intent or not, given that Darrell Brooks told Detective Carpenter that he could tell that something was going on down at the parade. So why did you drive through the parade, Darrell? Oh.
No reasonable person would drive upon this area, see the squads with their red and blues on.
Somebody with a mental illness would. His mom would probably argue that.
See the officers in the street with their bright yellow vests. See all the people milling around. See the floats lining up and the participants getting ready, and not know to drive safely, slowly, and obey officers.
Because it was an attack.
The barricades help us prove it was intentional. The police presence help us prove it's intentional. The parade participants help us prove it's intentional. And the parade spectators help us prove it's intentional.
Excuse me, Attorney Opper, your objection, sir?
Speculation as to what the alleged defendant said he saw. It
Sir,
was never.
Your objection's noted. It's overruled. This is closing arguments.
See, this is further proof that this man is not an attorney, because he wouldn't be making arguments during, watch this, a closing. This is not the time for that, man. Shut the hell up. Shut your mouth.
The evidentiary phase. Go ahead,
So
Attorney
how
Opper.
can
Shut up.
speculation be made to what was saw?
Shut up.
Objections noted. It's overruled. Continue, Attorney Opper.
Shut your mouth.
Honking the horn. Quite interesting that Mr. Brooks asked so many witnesses if they heard the horn honking. Some of them said they did at the beginning of the parade. Yeah, I heard a horn honk. Most of them said they didn't. The horn honking cuts both ways, folks. If he's honking his horn, that means he can see something's in front of him. That means he knows there's an object in the road. You can rely on your common experience in your affairs of everyday life. If you see something in the road and you want to alert the other person to your presence, you will honk. But you do not have the green light to then just keep going if they don't move.
Exactly. So that's intent.
He knew they were there.
Right.
Intent.
Right.
I've skipped one. I'm sorry. Going back to my street, number 15, I failed to include the Catholic community. That's just one of the photographs showing the people that will match up to Exhibit 15.
All right, listen, y'all. You get it. You get it. I mean, this is basically Opper had everything strategically mapped out. And this is why I said earlier, this is why the state could not afford to miss anything. They could not afford, Judge Darrell couldn't afford to screw up on that record, because the last thing they wanted is for Mr. Brooks to walk out of that courtroom with a victory. So, as I said, you get it. They had overwhelming evidence against him. There was absolutely no way out. That would be the acronym NWO. It was no way out for Darrell Brooks. And I think, and if you review this, she will assert to the jury that it's time. It's time, meaning that it's time for Darrell Brooks basically to come clean. It's time for Darrell Brooks to stop lying. It's time for him, really to be apologetical in light of the things that he did. There were so many things that he did during the tribunal that I really think that he believes, especially particularly at the end when he knew that those verdicts were in and Judge Darrell basically had the final say. Now, when I say final say, I don't say that she has the ultimate say. Of course, that is up to the Court of Appeals. But in this trial, once those verdicts were handed over and the power went right back to Judge Darrell, and she had the final say in light of the sentencing of what he did. And he knew that. And this is why he tried to become a good Samaritan. He was trying to jump on the bandwagon, trying to inform her that, because this, as you know, this was around October, and so that would constitute the whole Halloween. And he was telling her, watch this, during the sentencing, telling her that there were people dressing up as her as Halloween, and watch this, trying to divert the sentencing, trying to get the heat off of him, and she just plainly tells him, no, Mr. Brooks, I'm not here for accolades. This is not what I'm here for. I'm here to sentence you for the rest of your no good life. I know, well, she didn't say that, but that's what I'm saying. Essentially, that's what she was doing. I know that's right. But listen, y'all, we're going to end this, and we hope that you all will view this and share it so that others may become a part of this that I'm doing, taking down this fool, this other fool, not other, but utter fool of Darrell Edward Brooks.